Well, I'm going to go back to something we talked about a little bit ago, and that is making sure that you're entitled to the entire homestead. So if you have not had the property and you have to have acquired it, it's not the sort of thing where you lived in the property because, say, it was your parents' house and they died and now you inherited it and you've lived there for 20 years, but you've only owned it for a year. That's not going to do the trick. You have to have actually owned the property for 1,215 days. So if you haven't owned the property for 1,215 days and you want to do a Chapter 13, unless you have very little equity because the mortgage just dwarfs whatever the value of the property is, you probably want to wait, if you can, the full 1,215 days and then file on day 1,216. And that kind of thing is down to the day. So we certainly want to get a copy of the recorded grant deed when you got the property to make sure of the date it was recorded with the county recorder's office. But that's certainly something that you want to be absolutely sure of. Or if, let's say, you had been convicted of one of those felonies mentioned in Section 522 of the Bankruptcy Code, we might want to wait for the full 5 years to elapse so that you get the full benefit. If you don't wait and you only get the greatly reduced homestead, you might end up having a percentage plan that's close to 100%, or maybe it is 100%. Because remember, that Chapter 7 liquidation requirement absolutely must be met. So whatever the non-exempt equity is, and that is actually the non-exempt value of all of your possessions. Some possessions may be completely exempt, some partially exempt. Whatever that dollar value is becomes the floor for the Chapter 13 plan, as long as you don't exceed 100%. The plan will never pay back more than 100%. So the point here is we want to maximize the benefit by making sure you get the maximum equity exemption.